name's Tom Metzloff, and I have the pleasure of being the sort of faculty advisor to the Alaska Law Review. As almost all of you know, the Alaska Law Review has been at Duke University for over 35 years, and it's been our great pleasure, despite our distance from the great last frontier, to have the honor and privilege of being the law review for the state of Alaska, the only state that does not have a law school. And we normally have the pleasure of sending our new student editors, many of whom are participating in the symposium today, and they would have been up in Anchorage at least a couple of weeks ago for our fall break, but that didn't happen in the real world this year. It didn't happen for a lot of reasons. One, we can't travel, and two, there wasn't even a fall break. So one of the ways that most universities have handled the pandemic is to get rid of fall break, which I think is a terrible thing. But we are fortunate that we decided to move ahead with our symposium. This is our fourth symposium that we have sponsored and co-sponsored with the University of Alaska Anchorage and Professor Ryan Fortson in particular. And we are that alliance has been a wonderful thing for us, and we appreciate it here. 2 years ago, about this time, we had our prior symposium that dealt with the sort of 60th anniversary of the Alaska Constitution. And we were delighted to have as our keynote speaker, Erwin Chemerinsky. And as we came up with this topic on elections, we'll talk more about that in a second, we certainly thought, well, I know he just did it, but wouldn't it be great if Dean Chemerinsky would again be our keynote speaker? And I was delighted that he accepted our invitation. And I have the great pleasure today of introducing Dean Chemerinsky, who was my colleague at Duke Law School for 4 or 5 years back before he became dean at the first dean at the University of California, Irvine, where he did a simply remarkable job of establishing a new law school and immediately putting it on the map, before moving a few years ago to dean of University of California, Berkeley. This is probably the easiest job I've ever had in terms of introducing Dean Chemerinsky to an Alaska audience, because he needs no introduction. For over a generation, Erwin has come up to the Alaska Bar Convention and given his timely and insightful updates about the previous Supreme Court year, as well as commenting on Alaska's Supreme Court opinions during the year. And he has sort of been the really bulwark of the Alaska, the constant in the Alaska Bar Convention for over a generation. Unfortunately, that wasn't able to happen this year, another victim of the pandemic. But I think maybe that's perhaps why he was excited about joining us today, because this would at least get him a chance to be virtually back in Alaska doing what he has always done so well. But let me, even though he needs no introduction, do say a little something about Professor and Dean Chemerinsky. He has written over 200 law review articles and 11 books on matters of the Supreme Court and the constitutional law. It's a frequent commenter, including a monthly column in the ABA Journal that for me is absolutely must read. And I always want to know what Professor Chemerinsky and Dean Chemerinsky is thinking about particular issues. I looked back on his wonderful keynote address 2 years ago, and it came at a time that was very similar to what we're going through now. It was in the midst of the Justice Kavanaugh confirmation hearings, and he remarked, as we all in academia knew, how interested, concerned, upset, focused, many adjectives come to mind, that our law students were in that moment of the Justice Kavanaugh hearings. In just the same way now, our students and aspiring lawyers are interested, concerned, focused on both the election and what it means for the Supreme Court. Having a symposium as we are on discussion on sort of voting in the last frontier on election law certainly makes sense when we are just a few days away from a national election, but the timeliness of this topic is more profound than merely its closeness in time to a national election. The last 5 years has seen a remarkable number of issues in the election area come to the forefront of American constitutional law, starting with the Voting Rights Act and changes there, and more recently, in a case from North Carolina, the concerns with political gerrymandering. This week has been remarkable in that the Supreme Court, on almost a daily basis, is hearing appeals and petitions from states with various issues. One yesterday from North Carolina that ended up permitting our handling of absentee ballots. So the issues, both big and small, with elections, both on a constitutional level, but also on a state level, as we recognize more and more how much each of our states have sort of special, sort of peculiar, specific, unusual aspects to our laws, as how are we going to make this democracy work. So I'm very excited to have the opportunity to hear the insights and the analysis that Dean Chemerinsky will bring to this issue of election law and starting us off. So thank you, Dean Chemerinsky, and welcome back to Alaska.
Thank you so much, Professor Metzlaff, for that incredibly kind introduction. It's truly my great honor to participate in this symposium and be asked to do the keynote. As I said before, I feel a very special relationship both to Alaska and to Duke. As Professor Metzlaff mentioned, from 1990 through 2019, every year I came to speak at the Alaska Bench Bar Conference, doing a talk on the U.S. Supreme Court, for the last 15 years, one on Alaska Supreme Court and Court of Appeals decisions. So I've gotten to know a bit about Alaska law over this time. I was supposed to come this month for the Bench Bar Conference, but it, of course, had to be canceled. But I'm so looking forward to returning in 2021. And for reasons that Professor Metzlaff mentioned, I feel a very special connection to Duke and have such fond memories of the years that I was on the faculty there. So the honest answer, Tom, is I would say yes to anything that you and the Alaska Law Review ask. For all of the reasons Professor Metzlaff said, and for all the reasons that are obvious, this is an incredibly timely point to be discussing election law and Alaska election law in particular. I thought what I would do this morning is focus on three questions. First, what is the approach of the United States Supreme Court this year towards election law issues? Second, what historically is an approach to Alaska electional issues? And third, what are some of the most important current issues with regard to Alaska election law? So let me start with that first question, trying to situate any discussion about Alaska law in a more general context, asking what is the approach of the Supreme Court this year with regard to election law issues. I do think we have to talk about election law in the context of this moment. And there is a political context to it. And let me try to state it as fairly as I can in terms of the competing worldview positions. I don't think they've ever been as starkly drawn as they are now. The Republican position is that voter fraud is a major problem in the United States, that absentee ballots risk great voter fraud, and also politically Republicans perceive less absentee ballots is to their benefit. They see absentee ballots as much more likely to favor Democrats than Republicans. So what Republicans are seeking to do in litigation going on all over the country is limit the ability of people to cast absentee ballots and limit the time period within which they must be received in order to be counted. And we have none other than the President of the United States and the Attorney General of the United States articulating these themes. But there is a very different perspective articulated by Democrats. They believe that voter disenfranchisement is a major problem in our election system, especially so for voter disenfranchisement as to voters of color. They believe that absentee ballots are particularly important in a pandemic. Often in dissenting opinions, we have heard initially Justice Ginsburg and more recently Justice Sotomayor talking about how people should not have to choose between voting and risking their health in the COVID-19 pandemic. Politically, absentee ballots are seen as good for Democrats. So their goal is to expand the availability of absentee ballots and expand the time for counting. To me, what's most surprising about this is the extent to which judges and justices are paralleling the positions taken by the parties of the presidents who appointed them. That the justices on the Supreme Court and the judges on the lower courts appointed by Republican presidents are articulating just the themes that you're hearing from the president and the attorney general. And the justices appointed by Democratic presidents and the judges appointed by Democratic presidents are articulating the themes you're hearing from Joe Biden and Kamala Harris and the Democrats. It doesn't have to be that way, but it certainly is. Well, how is it manifesting itself? And what might we see between now and Tuesday or immediately after Tuesday? I think there's two things that we've seen. One is the Supreme Court is very much limiting the ability of the federal judiciary to change the rules of the election. There's all sorts of requests to the federal courts to protect the right to vote by changing rules of the election. Many states are very restrictive in who can cast absentee ballots. In Texas, in order to cast an absentee ballot, you have to be over 65, have a disability that keeps you from going to the polls, or be out of the jurisdiction at the time of the election. What you have there is a federal district court saying, expand absentee ballots, but the Supreme Court divided along ideological lines, overruling that. Where some states have requirements in terms of notarizing or witnessing absentee ballots. In Alabama, you had this. Federal district court said, open up absentee ballots, suspend these restrictions. The Supreme Court 5-4 reversed this. The most dramatic instance where we saw this was on April 6th of 2020 in a case called Republican National Committee versus Democratic National Committee. Wisconsin was holding its primary on April 7th. Wisconsin law said that in order to be counted, an absentee ballot had to be received by April 7th. Federal district court judge in Wisconsin said, there's a flood of absentee ballots because of the COVID-19 pandemic. So long as the ballots are received by the state by Monday, April 13th, they should be counted. The Supreme Court 5-4 reversed and said that federal district court was impermissible. Well, what's the reasoning of the conservative justices in this and other cases? You actually find the clearest explanation in a majority opinion, in this case, Republican National Committee versus Democratic National Committee. There was a per curiam opinion of the court, and it said that there's a principle that federal courts should not change the rules of the election soon before the election. And the court cites to Purcell versus Gonzalez, a 2006 per curiam opinion of the Supreme Court. In fact, this has come to be called the Purcell principle, that federal courts should not intervene and change the rules of the election soon before the election. Now, Democrats and the more liberal justices and judges would very much dispute that there's any such thing as the Purcell principle. They would say Purcell was not a case decided after briefing and oral argument. Also, Purcell made one factor among several, not having federal courts change the rules of the election before the election. But as the conservative justices, as the conservative judges and lower courts have interpreted, Purcell has become bright line rule. So just this week, federal district court judge in Wisconsin wanted to again extend the time for receipt of absentee ballots. And again, the Supreme Court reverses. This time, of course, it being 5-3, Justice Barrett didn't participate. I think we will see more of this over the next few days, that if it's a federal court trying to extend the hours of the polling place, extend the time by which absentee ballots have to be received, lessen the requirements for absentee ballots, you're going to see the 5 conservative justices saying no, the Purcell principle. Well, that leads me to the second point. It's unclear whether the Supreme Court is going to limit the ability of state courts to use state constitutions to protect the right to vote. Here I want to talk about something that happened a week ago Monday in the Supreme Court. The Pennsylvania Supreme Court, interpreting the Pennsylvania Constitution, expanded the availability of absentee ballots. Now, it's important to note here, this is not a federal court. It's not based on the US Constitution, but it is based on a state court interpreting the right to vote under the state constitution. Now, my initial instinct would be that's up to the states. Earlier, the Supreme Court allowed states, Rhode Island in particular, to change its rules of the election with regard to absentee ballots. Over the summer, Rhode Island election officials made it easier for absentee ballots to be cast, and the Supreme Court denied review. And the idea was, well, this isn't the federal court doing it, this is election officials. But what if it's the state court? And what if it's interpreting the right to vote under the state constitution? The Supreme Court a week ago Monday split 4-4 on whether to reverse the Pennsylvania Supreme Court in interpreting the state constitution. What's the argument that state courts can't do this? Well, we saw it articulated on Monday of this week in an opinion by Justice Kavanaugh, and it relies on an opinion from 2000 in Bush versus Gore that got very little attention at the time. Everyone remembers that in Bush versus Gore, well, I can't say everyone remembers. I realize that many of our students don't remember that. I was teaching a class this semester on COVID-19 and civil liberties. And when I was talking about Bush versus Gore, I realized that many of my students were under 5 years old at that time. In Bush versus Gore, the Florida Supreme Court said, under Florida law, all the uncounted ballots should be counted. Set a very strict deadline for it. The Florida Supreme Court said that on Friday, December 8th, and wanted all the ballots counted by Sunday, December 10th. But the Supreme Court of the United States, in a per curiam opinion, said, counting the uncounted ballots without preset standards violated equal protection. The reason I mention it here is Chief Justice Rehnquist wrote a concurring opinion joined by Justice Scalia and Thomas. And they said that Article 1 of the Constitution makes clear that it's the state legislatures that determine the rules with regard to presidential elections. That means state courts can't use state constitutions. Now, I was dubious of that when I read it in 2000. Why can't state courts use their state constitutions to protect the right to vote? State constitutions always trump state statutes. And in 2015, in a case called Arizona State Legislature versus Arizona Redistricting Commission, a majority of the court said legislature doesn't literally mean the state legislature. It means whatever processes the state has for deciding how votes will be cast and counted. But the four conservatives, Thomas, Alito, Gorsuch, and Kavanaugh, have revived that theory and said state courts can't interpret state constitutions to protect the right to vote. They can interpret state statutes because that's the legislature, but not state constitutions. In fact, Justice Kavanaugh, in his opinion on Monday of this week, cited Bush versus Gore, which is virtually the only instance which any Supreme Court opinion has cited Bush versus Gore since December 12, 2000, when it came down. The court split 4-4 because Justice Ginsburg had passed away and Justice Barrett hadn't been confirmed yet. One wonders, where will Justice Barrett come out on this if issues arise next week or after November 3rd? Will she be more likely to join Thomas, Alito, Gorsuch, and Kavanaugh than join Roberts, Breyer, Sinner, and Kagan? That's why I phrased this principle. It's unclear whether the Supreme Court will limit the ability of state courts to use state constitutions to protect the right to vote. You can tell my position on that from what I've said, but I would also think that conservative justices who believe in federalism and states' rights would want to encourage development of state constitutional law. And shouldn't state constitutional law always be able to trump state statutes. That's the context for talking about the Supreme Court in this election. Let me talk, as my second major point, about the history of the right to vote in Alaska. Article 5 of the Alaska Constitution is about suffrage in elections. Article 6 concerns legislative apportionment, something Professor Metzloff referred to in time about the Supreme Court's decision a year ago about partisan gerrymandering. And it's Title 15 of the Alaska statutes that govern elections. Obviously, in the time that Alaska has been a state, now over 60 years, there have been many issues with regard to voting rights in Alaska. I thought that I would focus on three that seem to me particularly important. The first I want to talk about is Native American voting rights. We are in the midst of a national reckoning with regard to racism. I think it's important to talk about the history of racism in Alaska directed at Native Americans, and particularly with regard to the right to vote. Alaska has the largest percentage of indigenous residents in the United States, but these individuals have long faced discrimination at polls and have often been overlooked in national enfranchisement efforts. Discrimination against indigenous Alaskans in the context of voting goes back to at least 1915, when a pre-registration process was established by law for Native Americans who were trying to gain citizenship status. The law was superseded by the Indian Citizenship Act of 1924. And in response, the territorial legislature enacted literacy tests the following years. There were very strict restrictions on the ability of Native Americans to vote in Alaska. In fact, until 1970, Article 5, Section 1 of the Alaska Constitution required that qualified voters be able to read or speak English. Due to often segregated educational systems in the territory, many Native Americans had limited English language proficiency, and the literacy requirements were an effective barrier to participation in the electoral process. This, of course, parallels what went on in southern states, where they created literacy tests to disenfranchise Blacks. In 1975, Section 203, and also Section 5 of the Voting Rights Act, meant that Alaska, in all of its political subdivisions, required to provide all voting materials in Alaska Native languages. And once initiated, none of this assistance could be removed without pre-clearance from the Department of Justice. Alaska was a jurisdiction that had to get pre-clearance under Section 5 of the Voting Rights Act because it did have a history of race discrimination in voting. There have been a couple of lawsuits that were brought under Section 203, Nick versus Bethel in 2007, and Toyakuk versus Treadwell. The substituted Mallet as a defendant in 2013. Both cases involve the failure of Alaska's Division of Elections to provide complete, clear, and accurate translations of all voting materials to Native voters. Both cases ultimately settled in favor of the plaintiffs. Many have said that the consent decree that was issued in the Toyakuk case transformed Alaska, and I'll quote, from a model of poor practices would be seen as a model of best practices for language assistance. There have also been studies that have been done that show that the pre-clearance requirement mattered in Alaska as the pre-clearance requirement mattered in other states. Unfortunately, the United States Supreme Court in Shelby County versus Holder in 2013 effectively declared unconstitutional the pre-clearance requirement. Nonetheless, a study that was done in Alaska in 2016 shows a dramatic improvement in the availability of bilingual poll workers, voting materials, and signage, though there are also indications in some areas of work to be done. The language barriers addressed by the Voting Rights Act in recent litigation are only one kind of obstacle that Alaska Natives have to overcome in order to vote. Some villages have been denied polling places altogether. The unique environment of rural Alaska, where sometimes a single polling machine must travel by boat and four-wheeler to reach voters, makes casting a ballot even more difficult. Early voting has been offered in Alaska, as you know, but predominantly it's been in non-native urban communities. Voting by mail also poses a challenge because the mail system in rural Alaska has already been very slow, not even accounting for what's gone on with regard to Postal Service budget cuts in the pandemic in recent years. The second issue that I want to talk about with regard to voting in Alaska concerns the initiative process. Like many Western states, Alaska has the possibility of adopting laws through the initiative process. This was seen as a progressive reform, and it began in the 19th century, predominantly in Western states, and then carried over into the 20th century. I grew up in Chicago, and I moved from Chicago in 1983 to California to take a job at the University of Southern California. And I was surprised in the fall of 1984 to get a phone book size pamphlet from the state. And I realized that just as my students may not remember Bush versus Gore, nor may they remember phone books, but imagine something really thick coming in the mail. It was all of the initiatives that were on the ballot in a description of them. It was so foreign to me to adopt laws through the initiative process. We certainly could have a discussion of whether the initiative process is a desirable way to adopt laws. On the one hand, it is democracy at its purest. It allows the voters to overrule the legislature or to act where the legislature doesn't. On the other hand, many of the safeguards that exist in the legislative process aren't there with regard to initiatives. For a bill to be adopted by a legislature, it has to go through committees, in a bicameral legislature in two houses, through both legislative bodies, be reviewed by a governor. Problems can be removed, corrections can be made along the way. But when you deal with an initiative process, so long as somebody's got the resources to pay signature gatherers and get something on the ballot, it can be done. Also, I worry that people are often asked to evaluate complex laws based on little information. In California, we are being deluged right now with ads about initiatives on the ballot. If you just follow the commercials, it's often hard to tell what the initiative is even doing. One of the key issues in Alaska with regard to the initiative process has been the single subject rule, that an initiative can be only about a single subject. The key case in Alaska is Gallant versus State in 1974. There was an initiative that dealt with both flood control and boat harbors, and the Alaska Supreme Court had to decide, well, is that a single subject? And the language from that case is still followed to this day, 46 years later, in evaluating what's a single subject. And there you find the court giving criteria in concluding that flood control in boat harbors was sufficiently related to be a single subject. Alaska's had to deal with this very recently for an issue that's on the ballot that I know is going to be discussed later in this program. The case was Meyer versus Alaskans for Better Elections. It's a 2020 decision. And I want to mention it not only because what it says about the single subject rule, because what it says about the importance of initiatives in the Alaska form of governance. The Alaska Supreme Court says, the Alaska Constitution provides that all political power is inherent in Alaska's people and, quote, founded upon their will only. The court says the people may exercise this political power in a number of ways. The people have the constitutional right to vote in a state or local election. And, quote, it is basic to our democratic process that the people be afforded the opportunity for expressing their will on the multitudinous issues which confront them. The Alaska Supreme Court says that a check on elected officials is the initiative process. And it specifically says there's a constitutional right to reject legislative acts by referendum and to legislate directly through the initiative process. Well, this concerns several different reforms of the criminal justice system that are in one initiative. I'll talk about it briefly in a moment, and there's a whole session about it later today. And the question was, does this meet the test for a single subject? And the Alaska Supreme Court said yes. The Alaska Supreme Court said the initiative embraces the single subject of election reform. It thus complies with the one subject rule. And it certainly is important in terms of the initiative that's going to be voted on just next week. Let me talk about a third issue with regard to Alaska election law that's gotten a great deal of attention, and that concerns political primaries and who can vote in political primaries in Alaska. I think here a case that I would point your attention to is the State Division of Elections versus the Green Party of Alaska in 2005. Alaska statutes that govern primary elections require that each political party have its own primary ballot on which only candidates of that party can appear. The Green Party of Alaska and the Republican Moderate Party of Alaska challenged that statute, arguing that by making it unlawful for them to present their candidates on a combined ballot, the statutes unconstitutionally violated their associational rights under the Alaska Constitution. And the Alaska Supreme Court held that the statutes, and I'm quoting, substantially burden the political party's ability to determine who may participate in its primary, and that the state's justification for imposing that was insufficient. The court held that those provisions of Alaska law violated the Alaska Constitution. And what I'd emphasize about this is the Alaska Supreme Court stressing that the political party should be able to decide who participates in its primary elections. The Alaska Supreme Court said, and I quote, "The Alaska Constitution protects a political party's right to determine for itself who will participate in crystallizing the political party's political positions to acceptable candidates." A more recent case about this was State versus Alaska Democratic Party just 2 years ago in 2018. The Democratic Party in Alaska decided to allow registered independent voters to participate in the Democratic primary. They wouldn't have to change their registration to become registered Democratic voters. Specifically, the Alaska Democratic Party amended its bylaws to do this, to allow independent voters to participate in Democratic primaries. They said that the goal was to expand the field of candidates and also nominate candidates who are most likely to prevail in the Alaska general elections. The Alaska Division of Elections refused to allow independent voters to be candidates on the Democratic Party ballot. They also refused to allow them to vote in the Democratic Party unless they changed their registration and became registered Democrats. And so the Alaska Division of Elections said that the party affiliation rule had to govern who was on the ballot and who could vote in the primary. The Alaska Supreme Court declared this unconstitutional. The Alaska Supreme Court said the party's right to choose its general election nominees, pursuant to the free association guarantee, included the right to allow independents to be candidates in the party's primary election. The court said that the Alaska law, as applied by the Division of Elections, infringed freedom of association under the Alaska Constitution. It said that the political party affiliation rule didn't advance any compelling state interests. It didn't advance the state's interest in ensuring public support for recognized political parties. The party affiliation rule was not, in the eyes of the Alaska Supreme Court, sufficiently narrowly tailored to meet constitutional muster. There's something that's implicit in what I've said about Alaska law, but it's worth making it explicit, and it certainly was the focus of what I talked about a couple of years ago in the remarks that Professor Metzloff spoke of. There is a strong tradition in Alaska of using the Alaska Constitution to protect rights, often to protect rights different than the United States Constitution. You see this in specific areas. The right to privacy is protected by the Alaska Constitution in its text and by its courts in a much more robust way than in the United States Constitution. When I teach criminal procedure, I often contrast what the Supreme Court of the United States has said to what the Alaska Court of Appeals and the Alaska Supreme Court have done. One of the benefits of having talked about the Alaska decisions over the last 15 years or so is being familiar with them. It's easy for me to contrast them with what the Supreme Court has said. So the Supreme Court has said a person has no right to privacy when it comes to garbage that's placed on the curb. The police can search without a warrant. But the Alaska Supreme Court has said that that does constitute an invasion of privacy. It requires a warrant. The Alaska Supreme Court doesn't use the levels of scrutiny that are so familiar under the US Constitution. It's come up with its own balancing test when it comes to competing interests. Well, I mention that because you also find this very much with regard to the right to vote and the right to political association. And as the United States Supreme Court has become much more conservative in recent months and in recent years, less likely to protect rights and advance equality, I think that generally there's going to be much more of a turning to state constitutions in state courts. And I think Alaska is already one of the leaders in this regard. But that also then ties back to my remarks at the beginning in terms of, will the United States Supreme Court allow state courts to use state constitutions to protect the right to vote? Or does it have to come only from state legislatures? That's why that split 4-4 on the Supreme Court from a week ago matters so much. Well, this brings me to the third and final part of my remarks. What's the pressing issues now? Now, it's presumptuous for me sitting in Oakland, California, to talk about what are the pressing issues in Alaska right now with regard to the election. The many of you who are in Alaska are the ones to speak to that. But as best I can tell from talking to some people and from my research, there's an initiative that's on the ballot, the Better Elections Initiative. It's called Ballot Measure 2, that's quite important. And I know there is a session about it today, so I will speak of it briefly. There is no need for me to cover what's going to be talked about in much more detail, but I also think I'd remiss to not talk about Alaska election law without talking about something that would be a major change in how Alaska conducts its elections. I think it would do several things. And of course, it's the very fact that it would do several things that led it to be challenged as violating the single subject rule under the Alaska Constitution. But that's what also led the Alaska Supreme Court to say, it's all about better elections. It's a single subject. One thing it would do is impose much greater restrictions with regard to disclosure as to campaign spending. It would try to deal with what we commonly refer to as the problem of dark money, where money gets spent, but we don't know who it is. We see a name of a committee that's responsible, but who's actually the funders of that committee doesn't get disclosed. So one of the things that Ballot Measure 2 would accomplish is it would require groups to write more public information about the source of money they donate to candidates. To put this in the context of the First Amendment in the United States Constitution, the Supreme Court has consistently upheld disclosure requirements. Citizens United versus Federal Election Commission in 2010 struck down the limits on independent expenditures by corporations and unions, but an 8-1 vote upheld the disclosure requirements of the McCain-Feingold Campaign Finance Reform Act. In fact, this goes all the way back to Buckley versus Vallejo, the key touchstone case with regard to campaign finance, upholding disclosure requirements. The only thing the Supreme Court has said is if it's a minor party, and it's very controversial, and disclosure were to chill contributions or expenditures, then there could be secrecy. And there's only one Supreme Court case, Brown versus Socialist Workers' Party, case coming out of Ohio, where the court has ever found that disclosure would be unconstitutional. And I think at least the framework that the majority had in mind in Buckley and Citizens United, and I acknowledge the composition of the court has changed even since 2010, was to say that spending money is a constitutional right, including of corporations, but the antidote should be disclosure and to give legislatures the ability for great disclosures. So I've studied ballot measure 2, and I don't want to preempt anything as we said this afternoon, but my sense is the disclosure requirements there would be upheld under what the Supreme Court has said, and they really are trying to get at this problem of dark money. Second, it would merge the state's 2 primary election ballots into one. Third, it would say that the top 4 vote getters in the primary, regardless of party, would advance to a general election, and it would use ranked choice voting, and it would have Alaskans rank their choice from 1st to 4th. Other states in the country, like Maine, use some components of these, but no state, city, or county employs all 3. Relatively few places employ ranked choice voting. As I say, there's going to be a lot more discussion of this afternoon, but I do think it would make an enormous difference with regard to how elections are conducted in Alaska. So that's the context for talking about elections this week. It's the context about talking about elections in Alaska. And as always, when I talk about Alaska law, I have to remark on how much Alaska has the chance to be a leader for the rest of the country. In many areas of constitutional law, it's been that. Alaska, under its constitution, legalized possession of small amounts of marijuana before any other state did so. Alaska has provided protections under privacy more than any other state. Alaska has provided, as I said, protections with regard to policing more than any state. And I hope that for some of what Alaska is doing and may do, it can really be a model for the rest of the country. And with that, I'll say, Tom, thank you so much for inviting me to do this.
Thank you very much. I appreciate it. I wonder if you would take a question or two.
Of course.
You've raised so many issues, and I was thinking back about election. If you look at the last 10 years, we've had such important and notable decisions in election law at the national level, and the ones that come to mind, I'm sure there's more, but Citizens United, which you've mentioned, the Voting Rights Act, Shelby, and then RUCO on the redistricting case from North Carolina. So redistricting, the Voting Rights Act, sort of repealed by the Supreme Court, and Citizens United. And what you're mentioning today is a really interesting one. It seems like Bush versus Gore is back alive again. We thought it was gone, but it's all on our minds. As you look at those, I believe from reading your work that you disagree with the Supreme Court in all of those cases. Which do you think in some ways has done the most, you're most concerned with its impact on American democracy? And what does the future bring for that? Yes, state courts are going to be important, but we still have to think about these issues on the national level. Kind of a big picture view as to what either the collective impact of those decisions are, or which one is troubling you the most.
Isn't it stunning that all 3 of the cases you mentioned, if you had Bush versus Gore, all 4 of the cases were 5-4 divided along ideological lines? And one of the things that troubles me that I alluded to, isn't it troubling that what the justices did was vote what would be best for the political chances of the party that appointed them? I mean, take Citizens United. Corporations outspend unions by as much as 15 to 1. unleashing the ability of corporations to spend unlimited amounts of money in election campaigns is what Citizens United has been about. I'm not worried about it in a presidential election. Both Donald Trump and Joe Biden raised enormous sums of money. I worry about it much more in local elections where spending is linked to name recognition, or where the ability to just drown out other voices is so much more possible. Shelby County, we know that the pre-clearance requirement with regard to the Voting Rights Act really made a difference. We can go through the hundreds of instances where the Attorney General denied pre-clearance. And then we can look at the instances where things that pre-clearance was refused for got immediately implemented in your state in North Carolina and Texas and other places. Or Rucho versus Common Cause. At the time the Supreme Court decided it, more state legislatures were controlled by Republicans than controlled by Democrats. So leaving the gerrymandering to the legislative process seemed a good thing. So Tom, I'm very concerned about all three of those cases. I think that they all are very bad for democracy. Citizens United and giving corporations so much ability to influence elections. Shelby County and taking away a key remedy that had worked so well with regard to protecting minority voters. Rucho versus Common Cause that leads to partisan gerrymandering through computers that really does mean that elected officials choose their voters rather than voters choosing their elected officials. But if I could tie it back to where I started, I've also been troubled how much the lower courts are paralleling the political party of the president who appointed them. So in Florida, a federal district court judge appointed by a Democrat said, you can't require ex-felons to pay their fines and fees in order to vote. The 11th Circuit reverses that in an en banc decision where every 11th Circuit judge appointed by a Republican president says Florida can disenfranchise ex-felons. Every 11th Circuit judge appointed by a Democratic president dissents. Or you look at the 5th Circuit cases, same thing, the split corresponding to the political party. It sure makes the courts look like arms of the political parties of the presidents who appointed them. And that to me is a very frightening development. So I didn't answer your question, I realize.
Oh, I think you
I
did.
can't pick among those three.
No, I think that maybe that's the answer. All of the above is always an answer. Is there something from the, as you look ahead to next week, I think you've given us the framework for your concern that, okay, it's one thing if the federal courts aren't allowed to sort of change the rules of the game for the states, but what about state courts? Is there any particular issue? I know Pennsylvania still has a cert petition out there. Is there one, I think we all pray that it's not going to be a Bush versus Gore moment again, but is there one scenario that really is keeping you up at night thinking about what's going to happen?
Everyone remembers the Iowa Democratic primary this year, where they simply had glitches with regard to the software and couldn't count. What if this happens on Tuesday? What if voting machines aren't working in a place? Or what if the lines at the polling place are so long and there's a judicial request to the courts to keep the polling place open longer because the voting machines broke or the lines are so long? Will the courts be there to protect the right to vote under that circumstance? What if we learn that the Postal Service has millions of undelivered absentee ballots? Will courts be willing to say, those people voted on time, their vote should be counted? Or will the court say, no, rigid deadlines have to be adhered to? And then there's the issues, and this is what scares me most, and I think I'm here paraphrasing Michael Lewis, the risk that I don't know. If you would have talked to me a few days before the November 2000 election, I could have never imagined Bush versus Gore and the litigation of that. I could have never imagined the butterfly ballot. If the election is clear, then there's a decisive winner. It's not going to matter. But if it comes down to 1, 2, or 3 states, and it's very much contested, and it goes to the courts. If I have a single scenario that most frightens me, think of states that have Republican legislatures, but the popular vote could go narrowly to Joe Biden. Pennsylvania being an example of this. Under the Constitution, the legislature could direct the electoral votes of the state go to Donald Trump. So what if Joe Biden wins as George W. Bush did in Florida by 350 or 500 votes? And the legislature that's Republican says, no, we think there was so much voter fraud, we're going to give our electoral votes to Donald Trump. And that then decides the election. We've never seen anything like that in history. And how then will people react? What will the courts do? That's what scares me the most.
Well, thank you very much. I appreciate it. And thank you as always for sharing your time, your expertise, and your insights to all of us in Duke and Alaska and everywhere else. So thank you very, very much.
Thank you.
Thank you. We are going to, Cormac, help me if I'm wrong on this. We're going to take a break now for about 10 minutes. And so let's see what time it is here. So let's start back at 1.
Well, before
go ahead, Ryan.
There is a question on chat, and if Professor Chemerinsky, Dean Chemerinsky, has time to answer that, I will state the question, and then you can respond. So the Alaska Supreme Court just within the past month held that Alaska ballots, absentee ballots, did not require a witness signature. Previously they had, but they ruled that in light of the pandemic, that was no longer going to be required. And the question is whether, in light of your discussion about the U.S. Supreme Court saying that state Supreme Courts can't interpret based on the state constitution, whether you think there's any risk that sort of after the fact, because a lot of people have been turning in absentee ballots without a witness signature, whether those ballots might be thrown out.
I do not know of any cert petition or petition for emergency relief having been filed in this case. People who are listening would know that. Obviously, if there was a petition for review, it would have had to been filed. Well, it's 90 days, but it would be, in fact, it would need to be an emergency petition. I think if there's no emergency relief from the Supreme Court, it's not a problem. I read it, and what I don't remember is, was it based entirely on the Alaska Constitution or interpreting Alaska statutes? Because
I don't recall off the top of my head.
Pardon?
Yeah, I don't recall off the top of my head whether it was solely on the Constitution.
Because if it's on the Alaska Constitution, then you come right into what the issue was in Pennsylvania a week ago and what the 4 conservatives are saying. If it's based on Alaska statutes, then that's different. But that would then come down if it comes, there's this whole issue where the court split 4-4 of whether or not states can interpret their state constitutions to protect the right to vote. And as I said, when Rhode Island did the same thing, eliminate the witness requirement, it was done by election officials, and the Supreme Court with 3 dissenting justices said, if state election officials want to do this, it's fine. But whether the state Supreme Court can do it based on the state constitution was very much what they divided on 4-4 last week in Pennsylvania. But the question, and I will try to find out, is whether anybody filed a petition for relief in the Supreme Court to stay the Alaska Supreme Court decision.
Okay, thank you. Okay, well, let's see. I don't see any further questions. There's some discussion on the chat.
My dear friend who I've known for over 50 years, Mary Alice McKean, I think I've just outed our age, Mary Alice McKean saying, it's so crazy that a state Supreme Court cannot interpret a state constitution. This was the Rehnquist approach. You can go back and read it in Bush versus Gore that Scalia and Thomas joined, interpreting the word legislature in the Constitution literally. But you should also read the Arizona State Legislature versus the Arizona Redistricting Commission in 2015, where the majority of the Supreme Court rejects it. But it's clearly the position that's now been picked up by Thomas Alito, Gorsuch, and Kavanaugh.
Thank you. Okay, so we are scheduled now for a break. We will reconvene at 9:45 for our first panel. I think because we have a waiting room, I would suggest not actually exiting Zoom, because then we'd have to re-let you in through the waiting room. So just mute yourself. Well, you should probably already be muted. If you want to turn off your video, I'll leave that up to you. But take a break and we will see you in a little over 15 minutes. Thank you.